Mr Tom Tugendhat.
Thank you, Mr Deputy Speaker. I'm very grateful for you being in the chair this afternoon, and I'm very grateful to be called on what is a very important subject, not just for me in Kent, but I know for many across our country, and from the messages of support I've got actually from many around the world. Now, lockdown has brought home the stress of childcare to many of us, and we've all learnt to respect teachers even more than we already did, and certainly I know that I'm not alone in being delighted that schools have reopened and that our children are able to expend the energy that they accumulate through the day in charging around a playground rather than charging around a sitting room. We have spoken frequently, of course, here as well about the importance of childhood and protecting the most vulnerable in our society, because we understand that failing to care for children is not just wrong, it's a betrayal of the trust that they should be able to have in our community and in the adults around them. But few betrayals, in fact no betrayal, is worse than parental abuse. This has been long recognised. 700 years ago, Dante wrote about it, putting the betrayers of family into the lowest circle of hell. And he was right, because those who harm their own children are beneath contempt, and our society should reflect that in our laws. And that's why I'm bringing this debate today. Over the past few years, I've had the privilege of getting to know an extraordinary young man whose story has moved much of the nation. Tony Hudgell from Kings Hill has become a household name in recent months thanks to his exceptional fundraising efforts in June. But this House has had the pleasure of his company before, and indeed were we not under the current regime, I'm no doubt that he would be in the gallery now, and I'm delighted to say that I'm perfectly certain that he's watching from home as we speak. I know that Paula and Mark, Tony's parents, will be supporting him, and he will be picking out individuals who he recognises, as he's been following politics for a number of years. Now, Tony's first visit to this House happened on the 8th of January 2019, when I presented a petition hand-signed by over 12,000 people asking for tougher sentences for child cruelty offences. Tony, his parents and supporters, who have become lovingly known as Bear's Army, spent the summer of 2018 heading across Kent in support of their campaign. You couldn't travel very far without hearing about the petition. You couldn't go into many shops without seeing it before you. Tony then made a further visit on the 12th of February 2019, when I introduced the Child Cruelty Sentences Bill to the House. Unfortunately, we were unable to have a time for the second reading due to the general election which followed last year. The purpose of the debate today, therefore, is to ask the government whether it will adopt the policies which that bill aimed to introduce. The Child Cruelty Sentences Bill sought to increase the maximum custodial sentence for the offences of child cruelty and causing or allowing a child or vulnerable adult to die or suffer serious physical harm to imprisonment for life. It is more commonly known as Tony's Law, in honour of that extraordinary young man, Tony Hudgell himself. It's worth remembering that Tony's story is pretty extraordinary and sadly horrific. But it isn't unique. Shortly after Tony was born, he was attacked by his biological parents. His fingers and toes were broken, the ligaments in his legs damaged. Despite extensive surgery, Tony had to have both legs amputated. He was only admitted to hospital 10 days after the injuries were sustained. It's impossible for us to know the pain that Tony must have suffered in those first few weeks of his life. Tony was lucky, however, extraordinary to say after recounting that. But he was lucky because he was adopted by a real family, by a loving family. And his real parents, Paula and Mark, who have loved and cared for him as a real family does, and a real family should, have given him an extraordinary home. His brothers and sisters and parents are an inspiration to so many, and certainly to me. They have given Tony the best possible upbringing after the hardest start in life. They are rooted in the community, both in Kings Hill and in the great kingdom of Kent. They are forces to be reckoned with, and their campaigning on this issue has won the appreciation of so many. For many years, I've worked with Paula and Mark for justice for Tony. We started back in 2016 when the Crown Prosecution Service initially failed to bring charges against Tony's biological parents. Eventually, charges were pressed and they got 10 years each in prison in 2018. Witnessing Tony's biological parents charged and sentenced for the crimes they committed brought a sense of closure on Tony's first few difficult weeks alive. But unlike his birth parents, Tony got a life sentence. Tony's law, as I shall refer to it throughout this debate, is not actually intended to help Tony. His biological parents, got the maximum sentence available at the time, and thank God, he has now found the home we all wish he'd had to start. Indeed, I hope this law will sit on the statute books and never be used at all. But it is the very least this House can do to recognise the extraordinary efforts of this inspirational young man. Tony's law aims to send a message that we cannot and will not tolerate severe offences committed against the most vulnerable amongst us. That just because you aren't old enough to vote or to run for Parliament, your life and your safety matters just as much as that of an adult. Now, Tony became a household name for many of us this year, and across the nation, he captured so many hearts. As part of his quest to improve walking on his prosthetic legs, Tony set a goal of walking 10 kilometres in 30 days to raise £500, just £500, for Evelina London Children's Hospital, just the other side of the river from here at St Thomas's, Mr Deputy Speaker. And that was the hospital where he himself received treatment and recovered from the horrendous injuries he had sustained. And for whom I know Tony's family and his friends are hugely grateful, and to whom I personally offer my very deepest thanks. Tony, who always seems to achieve the impossible, despite anything put in front of him, has demonstrated that his courage and the love of his family can actually carry him anywhere. He didn't, I'm sorry to say, Mr Deputy Speaker, raise £500. He raised £1 million and more. Not only that, but he smashed his target even further. And just last week, he started walking into school for the very first time. This debate asks the government to do what Tony has been doing for ages, helping those who need it most. I know that they're already aware of the remarkable young man that Tony is. Of course.
I'm very grateful. And he's speaking so movingly about this case. And can I add my support for Tony and his family, and also for his campaign, in anything I can do to bring about the changes he wants to see. But would he also support maybe a wider look at offences against children, the sentencing of offences against children, which often seem to be unduly lenient in some of these most egregious cases?
Could I thank my honourable friend, the member for Thurskland Moulton, for his words, and he's absolutely right. A review of child sentencing, I think, is required, because what we're really talking about here is demonstrating that our society, that this country, recognises that the most vulnerable require the most protection. Now, I was very pleased to say that in July, Tony received an award, and I was very, very honoured to carry it to him. The Prime Minister himself asked me to award a Points of Light award to Tony. And only a few weeks later, completely by chance, I'm sure, the Prime Minister visited Tony's school, the fantastic Discovery School in Kings Hill. Now, I know the Prime Minister will be listening to this debate, and I'm sure he remembers the conversation because Tony wasn't exactly shy about putting his case forward. As anybody who knows him will attest, he has an amazing sense of life, an amazing passion and no lack of confidence. He would make a fantastic member here one day, Mr. Deputy Speaker. Now, Tony hasn't forgotten meeting the Prime Minister, and those photos, I know, take pride of place. So for those of us who've had the honour of knowing Tony for many years, and for those of us who've seen share his drive, determination and commitment with the nation through his fundraising challenge, it's only right that we, as parliamentarians, show the support that the nation has already done by introducing a law, this law, in his name. Mr. Deputy Speaker, I should like to focus much of this debate on how we can enshrine into our legislation Tony's law, having been unable to progress the Child Cruelty Sentences Bill in the last Parliament. Now, that bill sought to amend both the Domestic Violence, Crime and Victims Act 2004 and the Children and Young Persons Act 1933 by extending the term of the relevant sentences. They are quite simply small amendments which would go a long way to ensuring that there is adequate sentencing for the most extraordinary cases, such as Tony's. And let's be clear, Tony's case is both unusual and extraordinary, and Tony's law only seeks to address sentencing of the most extreme cases. Figures from the Office of National Statistics show the outcome for offenders sentenced for cruelty to and neglect of children offences from 2014 to 2018 reveal that only 114 offenders received an immediate custodial sentence for these crimes. Each of these 114 cases is one too many and horrific, not just for the victims, but for the whole community. And the purpose of Tony's law is simply to increase the maximum sentence possible for judges to resort to in the most serious cases, to life imprisonment. Not all of these 114 cases receive the maximum sentences, and where a judge decides to give a more lenient sentence because of circumstances brought out in the trial, this legislation would make no difference. It would not change that. In Tony's case, which is included in these figures, the judge was extremely clear when he sentenced Tony's birth parents. Indeed, at the sentencing hearing in February 2018, Judge Philip Statman at Maidstone Crown Court, a court I knew very well, where I was put in the visitor's box as a form of childcare when my father was sitting as a Crown Court judge, he painted a very vivid description of the case. Understandably, he couldn't comment on the maximum sentence being 10 years. That's a matter for Parliament and the sentencing authorities. But he could say the following: I cannot envision a worse case than the one I had to deal with over the course of the last 2 weeks. It's quite something for a judge who has seen so many serious offences in his career. Following the two-week trial, the jury took less than an hour to return a unanimous verdict, and anyone who has even the slightest knowledge of our Crown Court system would recognise there was not much of a debate needed in this case. The courts are, of course, rightly separate, and sentencing, as we know, is, of course, up to the judge, but it is up to us as Parliament to reflect the views of our society and to legislate to ensure that judges are able to give sentences that reflect the crimes committed and the abhorrence that our society feels towards them. We can do our bit to support Tony's family by ensuring that the maximum sentence is appropriate for the crime. Under the current law, the maximum sentence for this crime is 10 years, what Tony's biological parents received. However, if Tony were an adult, the perpetrators would most likely have been charged with grievous bodily harm with intent, which faces a maximum sentence of life. How is it right that our law treats the most serious abuse against children differently to the abuse of adults? A child's life, as any parent will know, is the greatest responsibility anyone can be trusted with. And children are, of course, particularly vulnerable. They are under the care of others, and unlike most other groups in society, they have not got the same ability to influence not just policy and law, but even the space around them. We have a duty to protect children where the system or those responsible for their care fail them. We have a moral obligation to ensure that the law, in no uncertain terms, spells out that a child's life matters just as much as that of an adult. To do this, we need to empower the courts to give sentences to those who commit offences against children which match those for offences against adults. Whether it's an offence of child cruelty or grievous bodily harm with intent, sentences must be consistent, and we need to give judges the option of handing out longer sentences when needed, as Judge Satman could have done in Tony's case. The government's argument I do understand. I have been told that because in cases like this it is impossible to be certain who committed the harm, because, of course, of the impossibility of such a young child to bear testimony, the maximum sentence is capped. And, of course, I understand that that usually makes sense. There should be a limit on the sentences applicable when you can't be certain and the charge is shared. But this is different. This is very different. This is not just the violence committed against the child, but the very betrayal that parents owe to children. This is a violation of the foundation of our society, of the basics of our family, of the essence of community. It's not just a crime of violence. I will.
I'm very grateful. I just don't understand that as an argument, that because of the lack of certainty around guilt, you should cap a sentence, because clearly the court can make a decision on where there is doubt in that case and make a judgment accordingly in terms of length of the sentence. You leave that capability to the judge. Surely what he's trying to do is simply give the judge more discretion in the most egregious cases to give a longer sentence.
My honourable friend, the member for Thurston Moulton, is absolutely right. This law, or rather, the law that I tried to introduce, that I'm now arguing for, would not change the minimum sentence. So if there were extenuating circumstances, if there were reasons why the judge said that perhaps domestic abuse meant that the situation was not the same for both parties, the judge would have the discretion. But the judge would also have the ability, where it needed, to increase. Now, in this case, in Tony's case, it's true that I couldn't tell you whether it was one party or the other who inflicted the blows that did the particular damage to baby Tony. But I can tell you that they both failed. I can tell you for certain that in not calling an ambulance for 10 days, in watching that child suffer, in watching Tony suffer, they both failed. And they both failed in the most egregious and horrific way a parent can. And unless there are mitigating circumstances, which, as my honourable friend says, could easily be reflected and could easily come out in a court, the judge would have the discretion for a maximum sentence beyond the 10 years available. Now, I'm sorry to say, because I wish it weren't so, but this has become more urgent, not less. Coronavirus and the lockdown that we've all been through has increased the dangers faced by vulnerable children, not decreased them. New research by the National Society for the Prevention of Cruelty to Children has found that Childline has seen a 22% increase in the number of counselling sessions about physical abuse and a 53% increase in contacts from people with concerns about children experiencing physical abuse since lockdown started. While clearly not all of these will be criminal and far fewer worthy of the maximum sentence, the justice system must be able to respond to the most serious offences committed. The impact of physical abuse on children is not just severe, but enduring. Both the Alberta Wellness Initiative and the Harvard Centre of the Developing Child have published well-respected research which shows that experiencing trauma of any kind at a very young age can have a sustained and devastating impact on brain development. This impacts the ability to form and maintain relationships, It results in lower educational and employment outcomes, and it increases the chances of being victims once again. It can create extremely severe and long-term issues. Increasing the maximum sentence won't solve that. But parents must have a good understanding of developmental harm to children, and our court system must be able to send sentences to reflect this. Our judicial system already has the ability to determine which crimes should be classed as aggravating circumstances, and it is essential that the legal maximum sentences address the impact of any crime on the victim and on our whole society. Back in 2019, after the introduction of the Child Cruelty Sentencing Bill, I met with the then Minister responsible, the Right Honourable Rory Stewart, and he presented me with data from the Ministry of Justice showing how few cases per year of this nature and gravity occur. This is something I personally, and I know everyone in the House, welcomes. But we also need to accept the need to ensure that those few who are victims of these crimes are given justice which reflects the severity of crimes committed. We cannot have a justice system which fails to amend necessary legislation on the basis simply that only a few would have been impacted. I consequently wrote and met with the Crown Prosecution Service on the 4th of July last year, and I'm pleased to note that the Director of Public Prosecutions has raised my concerns with the senior judge who chairs the Sentencing Council. Indeed, I have a letter from the Director of Legal Services at the Crown Prosecution Service dated of the 19th of July 2019, which states that they, and I quote, still stand by to assist with any further work in relation to extending the statutory maxima for offences involving child cruelty. It is my firm belief, following these meetings, that should this government be willing to introduce Tony's Law, that the Sentencing Council would be able to update its guidance appropriately, and the Crown Prosecution Service would be able to lend their support to this. As I mentioned at the start of the debate, in Tony's case we, and I must emphasise I only played a very, very small part, because Paula and Mark are absolutely the heroes here and led the way from Kent Police and the Police and Crime Commissioner Matthew Scott in helping to persuade the Crown Prosecution Service to re-evaluate their original decision to push charges against Tony's biological parents for the crime which they had committed. It shows that, it shows that much work yet remains to be done. Not all children have a Paula or Mark in their lives. And it falls to us in this House to ensure that those children are heard too. The introduction of Tony's Law would be the best way to make this happen. I'm not particularly bothered if the government seeks to amend either of the two acts as I mentioned earlier, or finds an alternative route to bringing legislation. That is a matter for them and for the clerks. Indeed, it doesn't really matter how it is done, as long as the aims contained within Tony's Law can be implemented. What does matter is that those who have committed the most horrific crimes against vulnerable children serve the appropriate sentence. As a parent, I know there is no guidebook on how to care for or raise a child. It is hard work, and all of us know how many mistakes we have made. But having a child and watching them grow is the greatest privilege I've ever had, and I'm sure I speak for many in this House when I say that. And making the abuse of children the ultimate act of betrayal and the ultimate breach of trust is, I think, a duty that falls to us all. On average, around 700 people a year are convicted of cruelty to or neglect of children. They are rightly punished by our criminal justice system. This change seeks to focus only on those most serious cases where the abuse suffered by the victim causes life-changing injuries. And it only seeks to give judges a wider set of tools and the discretion to use them. Tools they would have if the victim were an adult. Tony Hudgell will never be able to walk like me or you, Mr. Speaker. Tony's first steps have been harder than anyone's, and he has proved, not in private, but in front of the whole nation, that he has the drive, determination and character to overcome any challenge or hardship placed in his way. He has won the nation's hearts and is one of the many heroes our country has cherished during this extraordinarily difficult time. He has won the appreciation and recognition of everyone from the Prime Minister and the Duchess of Cambridge, although probably most importantly for Tony, he's also won it from Chelsea Football Club. I hope that the government is willing to recognise this extraordinary young man and his achievements and introduce the law that is rightly in his name. Tony's law seeks to ensure that individuals who commit the most serious acts of cruelty against children face appropriate punishment when convicted of this crime. It would be a welcome and important step towards ensuring that our policies and our laws reflect the importance we place on children's lives and well-being. I look forward to the Minister's response and hope very much that we'll be able to work together in days to come.
Esther.
Thank you very much, Mr. Speaker, and I'd like to thank my honourable friend, the honourable member for Tunbridge and Malling, for securing this important debate this afternoon. I'm conscious that I only have, Mr. Speaker, a few minutes to do justice to what is a very, very important subject, and so I'd like to offer the honourable member an opportunity to discuss this matter further with me or with a minister in the department to discuss this further. But I would like to put on the record, obviously, that this story is both horrific and tragic, and no child should suffer what Tony has sustained at the hands of his biological parents. Like the honourable member, as a parent myself, I can't begin to imagine the pain inflicted on Tony and the physical and emotional impact that it's had on his life. I would like to pay credit to the work that his parents, Paula and Mark, have done in campaigning on this issue. And I know that they have worked hard, along with the honourable member, to draw this to the authorities' attention in a number of ways. In the short time that I've got, Mr. Speaker, I would like to point out that the offences of child cruelty to which Tony's parents were subjected and under which they were sentenced are not the only penalties that are available in this case. In a case such as these, you can be prosecuted also for a number of offences. For example, an offender can be prosecuted for GBH or for attempted murder, and both of those offences carry the maximum penalty of life imprisonment. And additionally, where the victim of a serious assault is a child, this is also a clearly aggravating factor and would likely lead to an increase in any sentence. It follows, Mr. Speaker, that the law and the penalties for the most serious cases are the same for children and for adults. In fact, the sentences imposed for offences against children often can be higher. I'd also like to point out, Mr. Speaker, that since the honourable member for Tunbridge and Malling first brought the matter to our attention, my officials have been looking at the sentences for child cruelty and have kept them under review. And statistics do show that currently there is no pressure on the maximum penalty for the offence of child cruelty because, indeed, as the honourable member pointed out, fortunately there are not many of these cases. And when